And now we move on to our very much anticipated closing keynote address, where I have the pleasure of handing the microphone back over to our CEO, Tony Fian, as she will introduce our keynote speaker, Commission Vice President Vera Jourová for Values and Transparency. So Tony, over to you.
Thank you, Konstantin. It is an honor, it is a real honor for me to introduce Commission Vice President Jourová, who is the European Commissioner for Values and Transparency. She leads the current Commission's work on values and transparency, the rule of law, and ensuring that the democratic system is protected from external interference. Specifically of interest to us, her portfolio includes work on countering disinformation while preserving freedom of expression, including the Code of Practice on Disinformation, of which IAB Europe is a signatory, and press and media pluralism. Her portfolio in the previous commission, my colleagues will recognize, was Just, where she oversaw the adoption of the GDPR, which we have been discussing this afternoon. And she's going to share with us some reflections on GDPR 3 years on. A very warm welcome, Commission Vice President, and the virtual floor is yours.
Thank you very much, and good afternoon to everybody. I have to ask my colleagues to collect the ideas which you gathered over this meeting, because of course GDPR is quite a topic to be discussed. And nevertheless, we have now maybe the reason to discuss about the GDPR, because it turned 3 yesterday, and I still remember how difficult it was to give birth to it 3 years ago, and also the time which was before the regulation coming into force, because there were at least 2 preparatory years for everybody. However, 3 years, this time span gives us sufficient perspective to assess if GDPR passed the test of time, what works and what else has to be improved. And I think in general that data protection and privacy, just like all fundamental rights, have gained in importance, not only because of the pandemic, but also due to the digital transformation we live. Internet, social media, online information sites, and streaming services have become a daily companion to many of us. And as we surf on the internet, we leave digital footprint, including many of our personal data. And this data becomes a valuable digital currency that is harvested, packaged, and traded, and as our today's host would know it, used for digital advertising and targeting. The data-hungry business model often remains a mystery for us, internet users, and it also creates a lot of risks. To me, it is clear that in order to preserve rights, especially in a digital reality, we need comprehensive rules that confer enforceable rights to individuals. A modern approach to regulation with a core set of individual rights are key to the response to the global challenges we face today. This stretches all the way from election campaigning through AI, Internet of Things, to the COVID-19 pandemic. We have seen enough to understand that strong data protection rules are not a luxury, they are necessity. And we have also seen that modern data protection rules are not preventing digital innovation, they are enabling it. This is the main gist of the privacy by design approach. I had the pleasure of finalizing the work on the GDPR. We had plenty of discussions how to design a regulation that will not deal only with the problems of the past, but be agile and flexible enough to deal with the problems of the future. Our answer was to strengthen enforceable rights, apply a risk-based approach, and have a uniform set of rules across the whole EU. And also COVID-19 pandemic put the test for those rules. I have to mention the pandemic because it is changing many things and also our way of looking at many things. So I'd like to pose a bit with the COVID-19 context. To fight the virus or help the recovery of our economies, innovative digital solutions can really make a difference. If we want these solutions to be reliable and effective, citizens need to trust them. Robust data protection safeguards are a key component of that trust. Contrary to what I sometimes hear, we do not have to choose between, on the one hand, the protection of personal data, and on the other hand, public health, security, or economic well-being. Rather than involving such false trade-offs, privacy is a prerequisite for allowing citizens to embrace innovative solutions without fear. In particular, the Commission put forward common standards of privacy safeguards for apps supporting the fight against COVID-19. This helped develop voluntary and secure contact tracing and warning apps that respect people's privacy and are interoperable so that these apps work seamlessly everywhere in the EU, across borders and across operating systems. Embedding privacy protections in the fight against COVID-19 is also part of our current work in developing an EU-wide digital green certificate, which is now called differently. So this is the original name of it, which the Commission chose. Anyway, this certificate will include basic data, such as the result of the test or information about vaccine to help retain free movement of people across Europe. To give an example, the list of data categories to be included in the certificates is shorter than what you would have in your yellow booklet for medical purposes. We do not need all this information to facilitate free movement. The GDPR is not an obstacle to the processing of health data, but processing this data in a safe manner benefits us all. And above all, this is about preserving who we are. Our values and rights should not be a collateral damage of COVID-19. Let me now come to your domain, advertising. During the COVID-19 pandemic, we have, more than ever, worked, shopped, and communicated online. The advertising potential is unquestioned. Advertisers were able to learn even more about our interests and provide tailored messages based on them. Personalized messages can play an important role delivering relevant information to us. They can also have a significant influence on how we see others and ourselves in relation to them. Advertisers may use different technologies to provide us with personalized messages. Many of them involve tracking user behavior across different websites and combining this information in detailed profiles. Such profiles contain large variety of information that can expose individuals and show their vulnerabilities. We cannot allow for further Cambridge Analytica incident to happen. We have learned that such methods, in particular the use of micro-targeting, harbor many risks. Micro-targeting as such is not mentioned in the GDPR, but it is closely related to the notion of automated decision-making, including profiling, which can have serious consequences. When it produces significant effect on individuals, it can only be carried out under strict conditions, namely with explicit consent of the individual, or if it is specifically allowed for. We cannot accept a surveillance model to cast a shadow on digital trust. So let me be clear, the GDPR must be clearly enforced. No half measures will do. But I also want to appeal to you, to the industry, as there are concerns about the real-time bidding advertising standard or the standard for data brokers. Online behavior of us, European consumers, cannot be broadcasted widely without safeguards. Sensitive data such as religion or health are protected by the GDPR, and consumers have to specifically consent to their use for the advertising purpose. And I would also expect the industry to not only assess legal aspects, but also ethical aspects and not target people's vulnerabilities. I would like to use this occasion to call on the ads industry to embrace both the letter and the spirit of the GDPR in the advertising industry. We also see a lot of problems in political advertising. This is why I will propose rules that we will increase transparency of political advertising online. This will be a lex specialis to the Digital Services Act, which will govern the general obligations of platforms. It is clear that citizens are not only consumers. The techniques used to amplify and target people with ideas or political messages are used to sow disinformation and amplify our existing divisions. Strong and effective enforcement of the data protection rules, also with respect to micro-targeting, is a precondition for protecting individual freedoms. As shown by the fine imposed against Google in the area of personalized advertising, the data protection authorities are not shy to enforce these rules. Now, the issues related to the mechanism, which is a very important part of the GDPR and which we call one-stop shop. The uniform application of data protection rules across the Union has been a major objective of the GDPR. In the core of the system that we put to place sit independent data protection authorities in the member states. These authorities are cooperating in cross-border cases and within the European Data Protection Board. The one-stop shop mechanism is a key asset of the internal market. To this day, data protection authorities have adopted more than 200 decisions following this procedure. And I have talked a lot about the uniform enforcement with Andrea Jelinek, the chair of the European Data Protection Board. And in fact, we will have another meeting very soon after our meeting here this afternoon. To me, it is very clear that the one-stop shop has yet to reach its full potential. More must be done if we want to have a truly European data protection culture. I am glad that the data protection authorities and the European Data Protection Board realize that there are problems and that they are committed to finding solutions. While I believe the GDPR creates an appropriate enforcement model, it requires goodwill and good cooperation. And if this cooperation in a decentralized way will not lead to effective enforcement of data protection rules in the EU, believe me, the appetite towards a more centralized European level model, like the ones we see in the competition cases or in the recently proposed Digital Services Act, so this appetite is likely to grow. But we are not there yet, and I continue to believe in the Data Protection Board and its consistency mechanism. I wish for the use of all tools in the GDPR to support effective enforcement, such as joint investigations or mutual assistance. Let me also touch upon the sensitive issue of international transfers. The question is how to effectively protect individual rights like privacy in our borderless, interconnected digital world, where transferring data takes a click or two, and how to do it in full respect of our EU data protection standards. The question has become even more relevant after the Schrems II ruling. This ruling has reaffirmed the need to ensure continuity of protection when data is transferred abroad. Our answer in the EU has been not to erect barriers, but to create bridges, to be open and to allow data to flow, provided that there is continuity of protection. Promoting strong privacy standards and data flows, and thus trade, can and should be complementary objectives. This is reflected in our ambitious agenda on trusted data transfers. For instance, we have recently concluded our adequacy negotiations with South Korea, 2 years after having created the world's largest area of free and safe data flows with Japan. We have also started talks with other Asian and Latin American partners. This is further reflected in our approach we are taking in our trade negotiations at both the bilateral and multilateral level. For example, in the recent trade and cooperation agreement with the UK, we included a straightforward prohibition of data localization requirements and an emphasis on the importance of data flows. We want to make very clear that genuine data protection on the one hand and digital protectionism on the other hand are two very different things. The way I see it, we are facing similar global challenges, and I am glad to see an increasing number of countries are converging towards putting in place modern data protection regimes, very often inspired by our GDPR. This is a global trend running from Brazil to Korea or from Kenya to India. In a world that is often fragmented, this increasing convergence offers new opportunities to harness the digital economy and better protect the data of our citizens. I believe there is now a momentum to work amongst like-minded partners and to reap the tangible benefits of increasing global convergence on privacy standards. This is why the EU is committed to continue to roll out an ambitious agenda on international data flows. This does not concern only adequacy decisions, but also developing other transfer mechanisms on the basis of the broad GDPR toolbox. For instance, in the coming days, the Commission will adopt a set of modernized standard contractual clauses. Such clauses represent a number of transfer mechanisms used by companies in the EU when trading with foreign customers and business partners. An important part of that work concerns, of course, transatlantic transfers. After the invalidation of the EU-US Privacy Shield by the Court of Justice last year. What is at stake are complex and sensitive issues for the US as for Europe that relate to the delicate balance between national security and privacy. But I believe that as like-minded partners, we should be able to find appropriate solutions on principles that are cherished on both sides of the Atlantic, which are access to court, enforceable individual rights, and limitations against excessive interferences with the fundamental right of data protection. Of course, any new solution has to be in full compliance with all requirements of the case law of the Court of Justice. This is not only a question of respect for the decisions of our highest court, it is also the only way to ensure the stability and legal certainty stakeholders expect on both sides of the Atlantic. It is therefore in the mutual interest of the US and the EU to reach a durable agreement that fully complies with the requirements of the Court of Justice's case law. To conclude, ladies and gentlemen, data protection is not going to go away. It is a necessary ingredient of any digital transformation. It is a fundamental right in the EU, and our highest court has established a stable jurisprudence on it. The protection of privacy and the protection against risks emanating from online platforms, social media, and new technologies are interlinked. They are all converging on the need to uphold people's rights in the online and the offline world. Europe needs to act now more than ever, and we are well placed to do it in our European way, balancing the need for innovation with the need of the protection of the individual. Technology that should serve the human being and not the other way around. And Europe, again, as a rule maker rather than a rule taker. Ladies and gentlemen, thank you very much for your attention.
Thank you. Thank you very much for such a wide-ranging set of comments. And perhaps I would only say very briefly on our behalf in reply that we are deeply invested in the European data protection legal paradigm. We are convinced that privacy, correct observance of privacy is the key to sustainability of our industry. We have developed a legal compliance standard that I believe we had the possibility to present to your office a couple of years ago, and that is attempts to incarnate the values that you have just spoken of, and that we estimate now is implemented on about 500,000 websites in Europe. We completely agree with respect to special category data. There's one legal basis, which is explicit consent. No two ways about it. Our framework actually doesn't enable processing on the basis of that legal basis. We need harmonized enforcement. We absolutely need harmonized enforcement. We appreciate your investment in and support for that. And it has been really interesting to see the sort of opening to more centralized enforcement in the DSA and DMA proposals, and to contemplate what lesson appears to be being learned from the GDPR experience. I think there's more convergence actually than sometimes is said, but it's definitely still a work in progress. So thanks again for a wonderful and very complete exposition, and I hand back to the host.